Remember on U.S. v. Taylor, what is the position? They've got to look at prior depositions. They've got to look at documents. They've got to review all of this stuff to get ready. So your job as a trial lawyer now is, there's a lot of these wonderful rhetorical things people talk about, and all about feeling the love and stuff. But I'm kind of a big fan of this little thing that sometimes we miss at CLEs, okay? I've taken the classes, I've studied with the masters, I've hired the consultants. I hired Joshua Carton, he got me really going well. I tried the wrongful death case of the perfect high school girl. Literally the jurors were crying. At one point we had to stop because one juror was weeping, and I got a $30,000 verdict. And they said, "Damn, Mark, you are really good. You had us going. Too bad you didn't have a case." and with that, I learned that those tools are the icing. That's a wonderful piece that you use to ring the bell. But there's something else you need. It's called evidence. It's a crazy thought, I know. But you need evidence. And so that's where you're trying to get it, through discovery. And discovery is an art form. There's a lot of stuff to it. And so as you're getting ready, you got to start thinking, what are the questions you get to start the evidence? So as we're trying to prove that these people are cheating, what has your organization done to prepare them? And some of my videos, you'll be seeing, what did you do? Because I've learned this through the School of Hard Knocks. It's the organization's responsibility to prepare them. So who has information that would be responsive to the matter of examination that you've carefully crafted in your notice? You see how all these pieces are starting to fit together? And then, did you talk to them? Did anybody talk to them? Because you want to find out if this witness has been properly prepared.
Yeah, in Kinder Danville, are there other people who also have information in response to items A through M?
My supervisor.
Who is your supervisor?
Peggy Ross. She's the business office manager.
Anybody else?
No.
Did you meet with Peggy Ross to talk to her about these questions that we have?
No.
This witness couldn't answer any question at all. Now, am I going to beat up on this woman? She was a lovely, lovely, honest woman that was brought in, and they threw her under the bus. And she was totally unprepared. So they said, well, you want us to bring Peggy Ross in, because they were nervous about not being prepared. What is the answer to that? You guys have learned. No, you don't ask for Peggy Ross. You say, you bring in anybody you want. You want to bring in Peggy Ross? Fine, but we want someone who's fully prepared to answer the questions. And that kind of threw him for a loop, but I wasn't going to get sucked into that trap. But yelling at this woman is not going to accomplish anything other than making you look like a jerk. But what we've done is, this guy, as you see, he's getting red. The associate next to him who prepped the witness was beet red because they didn't know the rules. I mean, they were actually really decent lawyers. They were good people, but they didn't know the rules. So they thought, we'll just get the person whose job description should be responsive to our question. So, you have to keep that thinking. So then, how about what else has been done to prepare you? Documents. What documents would be responsive to the questions that we're asking? And did they look at those documents? Because that's important. So let's see what the witnesses did.
Did you conduct a search for that nursing home ownership disclosure statement that you were required to file with the federal government?
I did not conduct the search.
Do you know if one was conducted?
No, sir.
So much for that. Once again, they didn't prepare. You're not going to get a motion. You don't have to worry about bringing a motion if you got the record. Now, if you're sitting there and she's answering questions as I don't know or we don't know, that's fine. But I've got on the record that they didn't even look. And that's a big deal. And that's an embarrassment for them. So when I brought this, they've got to bring a person fully prepared to provide all information known or reasonably available to the organization. But who did they bring? Hey, I'm clueless. And you folks have deposed clueless before, right? You got it, right? Sure. And so that's a problem. But what you do is you build the record and you know you're not going to get it on the first pass here when you're looking for information. So here's the deal. If they've got the wrong person, and this is pretty much all over the country, if it becomes obvious during the course of the deposition the designee is deficient, the organization is obligated to provide a substitute. And so what happens at that point? You reconvene the deposition. Those are cases all over the place. And what happens is I get into debates with my colleagues and they say, well, wait a minute, this is binding effect, right? Their lack of knowledge is binding on them, therefore, yeah, I got it. Well, here's the deal though. Courts don't like gamesmanship. They hate it. And so they have developed that rule about reconvening to get the right witness there. And I'm going, well, wait, Mark. Binding effect. Everybody knows that 30b-6s are binding. So that's kind of like the dogma, right? So what is the law? Turns out the rule is absolutely silent on the concept of binding. That was kind of a shock to me. I just assumed it was binding because we have so much that everybody just takes as gospel. So what do? You got to go back to the beginning and figure, where did this come from? Well, it comes back to a case called Marker versus Union Fidelity, North Carolina case 125 FRD 121. Not that important. But what the court there said is the corporation then must not only produce such numbers of persons as will satisfy the request, but more importantly, prepare them so they give complete, knowledgeable, and binding answers on the corporation. Bingo! That's the law of the world now, right? It's not in the rule, but Marker said that, and from that point forward, the waters have parted, and this is the law, and everybody's got to follow it, except when they don't, right? Because now we go to U.S. v. Taylor that postdates it and says, well, wait a minute. Yeah, it's binding, but what that means is it's not a judicial admission, but rather, just as in a deposition of individuals, if altered, it can be explored or explained through cross-examination. Well, that's like kind of BS because he's not thinking through how this plays out. What if a different witness from the organization or corporation shows up? How do you impeach someone with someone else's prior inconsistent statement? How do you get that into evidence? And what about the policy of the rule? Because the policy underlying the rule was we need to just quit this jerking around, this banding, and as a part of the judicial system, we're going to cut through the crap and get the information. And what happened with this is the organizations started figuring out, okay, we'll put somebody up, and later on we're going to go, sorry, we got it wrong. And then, and then when you try to cross-examine them on it, it says, well, we just, we did our best at the time, but what's really important is getting to the truth. And here's what the truth is. And what is that? That's called sandbagging. And so the law evolved on this. It's just like everything else, it evolves. And there's a big case, this is one you do want to know, Rainey versus American Forest, 26 Fed Sup 2nd, 82. And Rainey says, well, wait a minute. Here's what we got to start thinking about. Yeah, we're in the pursuit of the truth, but we also, the integrity of the judicial system needs compliance with the rules. So what the Rainey court says, unless the organization can prove that that information was unknown or inaccessible, it can't later change it. So what that's done is it's shifted the burden. The burden now is they've got to produce all information known or reasonably available to the organization. And if they get new information in the future, we do have to balance this getting to the truth with sandbagging. So they've got to prove that they couldn't have gotten that information before. Otherwise, they're stuck with it. And the big case, QBE versus Georgia, you'll like it for those of you who have your people do the legal research. This case has a summary of all the 30b-6 law in America as of 2012. The court actually says if there was a Bible of Rule 30b-6, this is what it would say. And it has 36 rules. And what the court says in QBE says, we're not going to let you bring new testimony at trial if you were unable or unwilling to testify and to provide that information. So what does that mean? If the witness did not prepare under 30b-6, then that court said, you know what, this is a sanction. Now remember, you're balancing this against the courts that said, well, you mistakenly brought the wrong person. They're saying you're going to be sanctioned. The alternative is, if there's no way you could get that information, then if you couldn't get it then, you're going to have to show why you can get it now. And then that's just the natural consequence of not preparing or not being able to get the information. And now we got some tensions in the rules here, which we see a lot, but our job as we're going to move forward with dealing with these obstructionists is we need to box in the designee. We need to ask the questions. Remember this morning when they're talking about closing all the doors and closing all the windows? And what you want to do is you want to identify all sources of information, okay? People, and they're not just employees. They could be former employees. It could be, you have to establish they have had the ability to get that information and that they didn't do it. Because if you don't ask those questions, they'll come up with an excuse in an affidavit that, yeah, we couldn't get it. That person was gone. And what we've had cases is when all of a sudden they've come up with new witnesses, we ask that witness, did you work for the corporation between the time of this event and the 30b-6 notice? Yes. Did you learn any new information since that time? No, I had all this information. Did anybody talk to you before the date of our 30b-6 notice? No. You've now made a record to try to exclude that testimony as a sanction. But we need the words. We need the magic words in a deposition to prove that they were cheating. So So we get into a crossroads on this binding effect because the 30b-6 actually has two functions. One is we want to get information. We want to get documents. We want to identify witnesses. We want to explain how the computer system works because we need this stuff to prove our case, right? On the other hand, we may want to get a position and lock them down on that position. And that's a very different thing. So as I'm going to go into my last 5 slides here, we're going to talk about the lockdown. Because you've already know how you can get the stuff by reconvening and getting another witness. If you want to do the lockdown, let's start with the question. What was Walmart Stores, Inc.'s position and or opinion as to how the incident occurred in which John Sullivan was struck on or about the head by a steel roller door at Walmart Stores, Inc.? We first want to make sure we got the right designee.
Deposition notice, which is asking Walmart Stores, Inc. to designate someone to speak on their behalf on 9 separate issues. Correct?
Correct.
Are you the person who's been designated to speak on behalf of Walmart Stores, Inc. with respect to those 9 issues?
Correct.
Okay, so we got the right person. We need to show that they were prepared.
You have to be fully prepared to provide all information known or reasonably available to Walmart Stores, Inc. about all 9 of those issues.
Correct.
Are you the right guy to do that?
Yes.
And have you prepared to speak on those issues?
Yes.
Okay, so I should have said, what did they do to prepare you? But we got him prepared. So now he's got the ability to prepare.
And Walmart has known about this event since May 4th, 2012.
Correct.
It's known about a lawsuit for, what, 6, 7 months now?
Correct.
You've had more than 30 days to investigate here, correct?
Correct.
And you've had every opportunity to investigate and prepare for this deposition, correct? Tell us everything that you have done to gain all information known or reasonably available to Walmart Stores, Inc. to determine how this incident occurred.
I've spoke with Gerald Lobb, who is the assistant manager that allowed access for Mr. Sullivan that evening. I've spoke with Jandy Jones, who was present when the incident report was filled out by Mr. Sullivan. I've reviewed the incident report that Mr. Sullivan filled out. And those would be the pieces specifically to the incident when Mr. Sullivan was hit that I've done.
Okay, so we got the preparation. Probably a better way to ask that question would have been, what did the organization do to prepare you? But now what we want to do is we want to go in for the kill shot. Okay?
What is the position of Walmart Stores, Inc. as to whether there was any error, malfunction, failure, misuse, and or abuse that caused or contributed to the incident in which John Sullivan was struck on the head?
At this time, it's unknown what created that situation.
And are you saying it's the intention of Walmart Stores, Inc. that sometime in the future come up with a different position?
No, because at this point, it's unknown on our behalf what occurred.
So at this time, it is a position of Walmart Stores, Inc. That there was no misuse of the door, correct?
Correct.
That there was no error, malfunction, or failure of the door itself, right?
Correct.
Yeah. And that's the position of Walmart Stores, Inc. is that Mr. Loeb had exclusive control of the opening and closing of that door at the time Mr. Sullivan came through it, correct?
Correct.
And it's the position of Walmart Stores, Inc. that there was nothing wrong with the door, right?
Correct.
And it's the position of Walmart Stores that Mr. Sullivan didn't do anything wrong, correct?
Correct.
Bingo! Summary judgment. Summary judgment on comparative fault. Summary judgment on liability. Little teeny law firm, boutique firm in Minneapolis takes on that little company in Bentonville and nailed it. So here's the takeaway. If size were all that mattered, the tiger would not fear the scorpion. And that's what 30B6 is. So thank you for having me.